Legal jargon made simple with your favorite criminal defense attorney, Nicole Naum. So today we're going to talk about what a prelim is. So we say prelim, what it really is a preliminary hearing. So when you're charged through an arrest warrant with a felony, your case will start in general district court or in juvenile and domestic relations court, at least in Virginia. So if it is in relation to a family matter or a child, it'll start in juvenile and domestic relations court. If it's adult on adult stuff, then it will start in general district court. But the district court level cannot hear felony trials because they are courts without a record. Does that mean there's no paperwork? No. What it means is that they don't have a designated court reporter to be at every hearing transcribing everything. So if you want a court reporter to be at your hearing at the general district court level, you need to hire your own court reporter. That aside, they still don't hear felony trials. So what these judges are hearing at a preliminary hearing is deciding whether or not there is enough evidence to the extent of probable cause to determine whether or not the case should be certified to circuit court. Preliminary hearings. What a client can expect from a preliminary hearing is one of four things. Oftentimes they get continued, so you show up to your preliminary hearing not ready to move forward. It's like the first time your attorney is really talking with the prosecution about the case, and we need more time to develop it and decide how we're going to move forward. So continuances are very common, especially for a first-time preliminary hearing. The second thing that can happen is they can amend the charge to a misdemeanor, or they can drop the charge via null pros, and then the case would either be dismissed without prejudice under the null pros, or it could be amended to a misdemeanor, and that could be with a plea agreement, or it could be amended to a misdemeanor and you could have a trial on a misdemeanor at the lower level. The third thing that could happen at a preliminary hearing is you could waive or give up your right to a preliminary hearing. That is not advisable to give up any of your rights unless you're getting something in return. There are things that you can get in return for waiving a preliminary hearing, which would be valuable to a person. But if the preliminary hearing is more valuable to your case, then you should not waive. And then the fourth thing that could actually happen is you have the preliminary hearing. It's advisable to have a court reporter at preliminary hearings just in case that hearing does go forward so that you can get a transcript of what occurred, especially on more serious cases, because this is your first opportunity to prepare for a trial. So preliminary hearings, super important, and that happened at the district court levels.